The quota catalyst, redefining enforcement through metrics. The landscape of American citizenship is currently facing an unprecedented tremor, triggered not by a change in law, but by a shift in internal bureaucracy. Historically, the process of denaturalization, stripping a person of their acquired citizenship, was a rare, almost surgical legal tool. With a national average of roughly 15 cases per year, it was reserved for the most egregious instances of fraud or national security threats. However, newly surfaced internal documents from 2026 suggest that the era of exceptional use has ended, replaced by a rigid, high-volume mandate. United States Citizenship and Immigration Services, USCIS, has reportedly transitioned to a performance-based model where the objective is no longer just quality control, but numerical output. These leaked directives instruct officials to flag and funnel between 100 and 200 cases every single month to the Department of Justice. When you do the math, this represents a pivot from a dozen cases a year to a potential 1,200 to 2,400 annual referrals, a staggering statistical leap that signals a fundamental transformation in how the government views the permanence of naturalized status. By framing immigration enforcement through the lens of performance metrics, the administration has essentially turned a high-stakes legal process into a production line. This shift suggests that the government is no longer just looking for bad actors as they arise, it is actively hunting for them to satisfy a monthly quota. For millions of naturalized Americans, this change in strategy transforms the government's role from a gatekeeper of the American dream into an auditor of its citizens' pasts. While the leaked quotas might suggest a rapid administrative purge, the American legal system provides a formidable defense for naturalized citizens. Citizenship is not a temporary permit that can be revoked by a clerical error or a bureaucrat's whim. In the United States, the power to strip citizenship is removed from the executive branch and placed solely in the hands of the Article III federal judiciary. This means a USCIS referral is merely the start of a grueling legal marathon, not its conclusion. The most critical protection is that denaturalization requires a judicial order. USCIS has no statutory authority to unilaterally cancel a certificate of naturalization. To succeed, the Department of Justice must file a formal lawsuit in a U.S. district court. Unlike immigration court, where judges are employees of the Department of Justice, federal district judges are independent, hold lifetime appointments, and are bound by the Constitution to act as a check on executive overreach. Furthermore, the government cannot revoke your status for small omissions or minor lies. Following the landmark Supreme Court ruling in Maslin-Jack v. United States, the government must meet a strict materiality threshold. It is not enough to prove that a naturalized citizen lied. The government must prove that the lie actually mattered to the outcome of the case. The legal test asks whether the truth would have legally disqualified the person from becoming a citizen at the time. In reality, forgetting a traffic ticket or a minor address change from 15 years ago rarely meets this standard because the fraud must be material, meaning it directly influenced the original decision to grant citizenship. Additionally, the burden of proof is exceptionally high. In a typical civil case, the standard is a preponderance of the evidence, or simply being more likely than not. However, because citizenship is so precious, the Supreme Court has raised the stakes for denaturalization. The government must provide clear, convincing, and unequivocal evidence that does not leave the issue in doubt. This is a massive legal hurdle, often described as nearly as high as the beyond a reasonable doubt standard used in criminal trials. The system is designed to favor the citizen. Facts are construed as far as reasonably possible in favor of the individual, and federal judges historically view the stripping of citizenship as an extraordinary remedy that should be used only in the most egregious cases of deliberate fraud. The leak of these quotas suggests a floodgate strategy, but in reality, the government faces a massive logistical bottleneck. The leap from 15 cases a year to over 1,000 annually isn't just a policy change. It's a physical and financial impossibility without a radical expansion of the federal government's infrastructure. It is vital to distinguish between a referral and a filing. A referral is merely USCIS sending a file to the Department of Justice as a tip, whereas a filing occurs only when a DOJ attorney signs a formal complaint to open a case in federal court. The DOJ is not a rubber stamp, and each referral must be scrutinized by the Office of Immigration Litigation to see if it can survive high legal standards. If a referral is weak or based on a minor error, the DOJ may simply decline to prosecute it, as filing losing cases is a waste of their limited resources. Furthermore, the Office of Immigration Litigation is already operating with a full plate, handling appeals, mandamus lawsuits, and complex litigation. To manage 100 or more cases a month, the DOJ would require a small army of new, specialized trial attorneys, paralegals, and investigators. Litigation is incredibly expensive, and each denaturalization case can take years of discovery, depositions, and trial prep. Without a massive appropriation from Congress for this surge, the DOJ lacks the personnel to turn thousands of referrals into lawsuits. Even if a case is filed, it enters a federal court system struggling under a historic backlog where judges are already managing thousands of criminal and civil matters. A judge cannot simply skip to a denaturalization case, as these must wait for available docket space. Additionally, federal judges, who enjoy lifetime tenure and independence, often push back against enforcement surges that bring poorly prepared cases into their courtrooms. If the government floods courts with minor cases to meet a quota, judges are likely to dismiss them quickly, further slowing the government's momentum. While the threat of 200 referrals a month sounds like an assembly line, the reality of federal litigation is more like a sieve, where much of what is referred by USCIS will likely be filtered out by the DOJ or stalled by the lack of space in federal courts. Quantity versus quality, the perils of the quota system. The introduction of a rigid numerical mandate fundamentally alters the psychology of an enforcement agency, shifting the mission from protecting national integrity to satisfying a spreadsheet when success is measured solely by hitting a target of 200 referrals per month. Investigating complex fraud, such as hidden war crimes, international money laundering, or deeply embedded identity theft, takes months or years of meticulous research and cross-border cooperation. While these are the high-quality cases the system was designed for, they are difficult to find and time-consuming to build. Under the pressure of a monthly deadline, USCIS officers may feel incentivized to pivot toward low-hanging fruit, which includes cases involving minor technical errors like miscounting days spent abroad, forgotten nonviolent misdemeanors from decades ago, or simple administrative discrepancies regarding previous addresses and employers. Because these errors are easily spotted in digital databases, they become easy wins for officers trying to meet a quota, even if they do not truly meet the legal standard for denaturalization. This focus on volume over value is likely to trigger a rejection reflex within the Department of Justice and the federal courts, as career DOJ attorneys are generally reluctant to file cases they know they will lose and will likely reject a vast majority of minor error files to protect their professional reputations. Furthermore, federal judges have little patience for nuisance litigation, and if the government floods courts with trivial mistakes, judges may respond with harsh rulings that set even more restrictive precedents, effectively weakening the government's legal position by trying to cast too wide a net. Perhaps the most significant danger is the erosion of the presumption of permanence, as treating citizenship like a monthly performance metric causes it to feel like a conditional status rather than a permanent one. This creates a chilling effect where even law-abiding naturalized citizens may hesitate to engage with government agencies or travel abroad, fearing that a minor, forgotten detail from their past could be exploited just to satisfy a monthly administrative quota. To truly grasp the impact of these leaked documents, we must step back from the 16,000% increase headline and look at the broader landscape of American immigration. When we compare the new referral quotas against the total population of naturalized citizens, a more balanced and less terrifying picture begins to emerge. The United States is currently home to approximately 25 to 26 million naturalized citizens, and every year, USCIS welcomes a massive new cohort of Americans. For instance, in fiscal year 2024 alone, roughly 818,500 individuals took the oath of allegiance. If we take the high end of the new quota, 200 referrals per month, that equals 2,400 referrals per year. While this is a massive jump from the historical average of 15 cases, it still represents a tiny fraction of the community, amounting to roughly 0.29% of annual naturalizations and approximately 0.009% of the total naturalized population. It is statistically probable that in a group of nearly 1 million people, a small number may have committed serious fraud, such as concealing violent criminal histories or ties to organized crime, and the legal system is designed to catch these extreme outliers. As established, a referral is simply an internal handoff. And if the Department of Justice follows its stated priorities, it will focus limited resources on national security threats, human rights violators, war criminals, those involved in major cartels, and individuals committed to serious financial fraud. For the vast majority of naturalized Americans, those who were honest about their backgrounds, have no criminal records, and obtained their status through legitimate channels, the statistical risk of being targeted remains near zero. The shock waves mentioned in the news are real because they represent a shift in government intent, but the mathematical reality is that citizenship remains one of the most stable and secure legal statuses in the world. The five-alarm fire is largely a policy shift targeting a very specific, very small group of people, even if the rhetoric surrounding it feels universal. The human and social impact. Vigilance in an age of uncertainty. Beyond the legal jargon and statistical probabilities, the true weight of a quota-based enforcement system is felt in the heart of American communities, where a pivot from viewing citizenship as a permanent bond to a revocable privilege creates ripples far beyond those directly targeted. This shift triggers what sociologists call a chilling effect, where millions of naturalized citizens, individuals who have built businesses, raised families, and participated in democracy for decades, suddenly face an atmosphere of conditional belonging. Research indicates that when immigrant communities feel under siege, they often withdraw from civic life and avoid essential services, fearing that any routine interaction with a government agency could trigger a retrospective audit of their immigration history. This retroactive anxiety is heightened by the power of modern digital tools to cross-reference old paper applications with current databases, making a simple name discrepancy or a long-forgotten address gap feel like a potential material misrepresentation. Furthermore, denaturalization is rarely a solitary event. Because many citizens sponsor family members, the revocation of one person's status can jeopardize the legal standing of an entire family tree. Under current law, a spouse or child who derived citizenship through a parent may lose their own status if the parent's naturalization is found to be procured by willful misrepresentation, turning a single legal case into a multi-generational crisis that threatens households deeply integrated into American life. In this climate, the goal of leaked documents is often to create deterrence through fear, but the most effective defense is informed vigilance rather than panic. Vigilance means knowing your rights, securing copies of original immigration filings, and consulting legal counsel about past discrepancies, while panic assumes a referral is an automatic defeat. As we have established, the path to revoking citizenship is long, guarded by independent federal judges, and paved with a clear and convincing evidentiary standard that remains one of the highest in the American legal system. While the administration in 2026 may be ratcheting up the pressure, the constitutional protections surrounding citizenship remain a resilient fortress that has not been breached. It is simply being tested. Ultimately, while the jump to over 1,200 annual referrals is a seismic policy shift, the gavel still belongs to the judge, not the bureaucrat, and by understanding the process, from the referral bottleneck to the high bar of materiality, naturalized Americans can stand firm in a status that the law is bound to protect.